Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Mark Erickson, and Mark is a family law attorney whose firm is located in Campbell, California. He graduated with a JD or law degree from Santa Clara University School of Law in 1979. He was admitted to the California State Bar and U.S. District Court, Northern District of California in 1979. It's amazing how those years go, isn't it?
Sounds like a long time ago.
Jeez. Anyway, after working for another attorney, mostly in the areas of civil and business litigation, from 1979 through 1984, he founded his law firm in 1985. He became a certified family law specialist by the Board of Legal Specialization of the State Bar of California in 1987. He has lectured and presented seminars for many groups, including as a teaching assistant and guest lecturer at the Santa Clara University School of Law. And Mark's oldest son is following in Dad's footsteps. He's also an attorney, and he's practicing with Mark and his law firm. Today, Mark and I are going to be talking about some basics of property issues related to divorce in California. And this is a complex area of law for which you should consult your own attorney, and also be aware that divorce laws vary among the states. We have this on YouTube, so you may be from another state when you see this. And we have a number of interviews that I've done with Mark over the years that you can find, and we'll also have some other ones that we'll be following up from this particular one this year. So just if you go to financialinsiderweekly.com and you look under past episodes, and then you sort of search through the list of past programs, you'll find some of those interviews with Mark. Mark, thanks for joining me today.
Thank you for inviting me.
Okay. So Mark, how does this whole divorce process get started?
Well, the formalities of starting it are based upon somebody filing a petition for dissolution of marriage. Mm-hmm. It's something that requires you to be a resident of the state for at least 6 months, and the county in which you file for at least 3 months. I guess sometimes the decision to actually end a marriage, it may have been a joint decision. It might be a unilateral decision. Sometimes people have made this decision many months or many years ago before they actually start the process in court. But the actual process is filing what's called a petition. It's a simple form that gives the parties' names, children's names, and birth dates if they have children, and a few boxes that you check, and a couple of collateral documents. But it's a fairly simple process. I always tell people if they decide to file today, they probably could get their paperwork done and file that same day.
Right. So getting the process started, it ain't so difficult. It's getting through it all. It's
Yes.
And as I understand, in California, we have like no-fault divorces.
Yeah, when we talk about no-fault divorce in California, what we're saying is you don't have to establish any grounds based on fault to terminate your marital status. All you need to do is one party needs to say that they have irreconcilable differences that have led to the irremediable breakdown of their marriage, and that's enough. That plus the passage of 6 months after the respondent is served with a petition.
Okay. Well, when is the right time to file for a divorce?
People debate that all the time. It's a question I often ask people when they do file, because it's not uncommon for people I see to say that they really knew their marriage was over 10, 15, 20 years ago. And for some people, it's when their youngest child graduates from high school. It seems to be a very, very common time for people to file.
Yeah.
Sometimes it's a crisis that creates a filing, maybe a domestic violence incident or a concern about a financial issue, perhaps concerns about custody of children that might cause somebody to file sooner rather than later. And a lot of people wait. Very common. It's December right now, and a lot of people may be planning on filing but they'll wait until after the first of the year, especially if they have children. A lot of people like to wait until the holidays have gone by before they file. In my experience, there are a lot of people that plan on filing shortly after the first of the year.
Frightening thought, but anyway, okay. Okay. And I mean, this is traumatic, especially financially. So it seems to me that there are a lot of people that decide, I'm just not going to do this.
I think that's true. I think a lot of people, maybe they both decided their marriage is over, but that it's financially advantageous for both of them to stay together and peacefully coexist, as opposed to dividing assets in half, divvying up income or whatever else might happen in the process, as well as the expenses of going through the process.
Right. So what do you think the most difficult area is related to this area of property settlement and so forth in a California divorce?
There are a lot of issues that are emotional, such as child custody issues can be very difficult. Support issues can be very difficult because a recipient may be very needy and the payor may be very reluctant to give away a portion of their income. But from my standpoint, some of the hardest part is getting through the disclosure and discovery aspects. The law provides that both parties have a duty of full disclosure during the course of the dissolution case, and that duty of disclosure, as well as fiduciary duties toward each other, continue until all of the assets have been divided, awarded, and distributed. And sometimes that's years later. The parties initially are supposed to, within 60 days, prepare what's called a preliminary declaration of disclosure, which at a minimum includes an income and expense declaration. This is on a multi-page form that parties are provided where they disclose their income and their expenses. And some people have great difficulty doing that, particularly if their income is variable or if they're self-employed. And some people just aren't good working with forms and numbers. And then they also, at a minimum, need to prepare what's called a schedule of assets and debts, where they list assets and debts, as well as identifying any property or debts that they claim to be separate property as opposed to community property. And what I find is it's very difficult to get people to meet those deadlines. I mean, sometimes literally years later, people are not getting their forms and their disclosures done, which can be dangerous because the court has authority on request to impose some serious sanctions against parties who don't make full disclosure in a timely manner.
Uh-huh. So I imagine sometimes it can be challenging to you as an attorney to get your clients to be forthcoming.
Yes, and I think it's usually not a matter of people wanting to hide something. I think it's often more procrastination, or maybe it's painful, especially early on going through that process. And as I said, I think some people just are not good with numbers. And surprisingly, very often one spouse has all the information and the other has little or no information. It is not unusual in some marriages to find out that one person controlled all the finances and gave the other person limited access to that information. One person prepared the tax returns and the other person merely signed them, or these days, of course, with electronic filing, they may not even see the tax returns that have been filed. And so sometimes it's a problem of gaining access to the information that's needed. And I think that's the whole purpose of the law requiring full disclosure. There's a recognition that sometimes one person does have more information, and we want both sides to be fully informed and adequately informed to be able to either make decisions on how to settle their case, or if they go to court, to have sufficient information to put their case on.
So what's the role of, say, a forensic accountant in this process?
Well, we often use forensic accountants. In a simple case, there may be no need for a forensic accountant, but there are certain issues that come up where they're almost required. For example, if there's a business asset owned by one or both of the parties, it may have to be valued. Professional practices usually require valuation. So if you have a self-employed doctor, attorney, accountant, you're probably going to hire a forensic CPA to evaluate the value of that business and the community property interest in it. And sometimes there are characterization issues. A business may have started during the marriage, or excuse me, before the marriage, in which case it would have a separate property component, and then the portion during the marriage, that growth during the marriage might be community property. So those are some of the complexities. The other is we frequently have income disputes during the marriage, and this comes up primarily with self-employed people, people that do contract work, real estate agents, people with variable incomes, certain occupations where it's easy for people to hide income or inflate expenses. So CPA can be very important in working through that to try and give the other spouse an opportunity to fairly prove what the income of the other spouse is, which can be very important in setting child support, spousal support, or making attorney fee and cost orders.
Okay. What are some issues relating to the family residence?
Family residence is often the biggest asset during the marriage, and so it can create disputes between parties. One of the more common ones is when one spouse contributes separate property toward the acquisition of a residence. So very common, folks get married, they buy a house sometime after the marriage, but one spouse already had a house and they maybe sell it and use that money to contribute to the down payment for the next house, or they have savings. So that's a common way that you see a separate property contribution, and the law provides that the contributor is entitled to reimbursement for that contribution. We also see title changes during the marriage that can raise problems where one party claims they were later taken advantage of by a change in title. For example, somebody owns a house during the marriage, the other spouse convinces the owner of the property to change the record title from separate property to community property of both parties. And then at the time of dissolution, when one party is advantaged during a transaction between spouses during the marriage, there's a presumption of undue influence. So we see a lot of litigation where one side or the other is trying to have a deed set aside, restoring the ownership to what it formerly was before a title change during the marriage. You see this a lot with refinances during the marriage.
Yeah, well, yeah, the banks always seem to require that you, or not always, but quite often they're requiring changes of title to a simple form for their requirements, but then they may be creating all kinds of side issues. And the problem with some of these is that they make this change, but then they don't change them back.
Well, and that's often the issue.
Yeah.
And what we hear all the time is, my husband told me I had to go to the title company to sign some papers. It was no big deal. I went to the title company and I realized I was changing ownership of the property from mine to both of ours. And my husband promised that shortly thereafter we'd change the title back, but it never happens.
Yeah.
At least that's what we often see
Yeah,
in our
it just
cases, is it doesn't happen.
Yeah, so there's just a lack of follow-through there. Okay. Are there differences of how community property is treated for a divorce as compared to, say, a death situation?
Well, the reimbursement claim I talked about for a down payment on family residence, or it could be another asset where there's a contribution of separate property toward the acquisition of community property. In a dissolution of marriage, Family Code Section 2640 provides that the separate property contributor gets that contribution back at the time of divorce without any appreciation or any change due to inflation or change in monetary value. 2640 does not apply in the case of death. It's only a dissolution of marriage statute.
Mm-hmm. Mm-hmm. Okay. How is mediation used as an alternative to a court proceeding?
It's very common and certainly permitted. There are a lot of attorneys now that have limited their practice to forms of dispute resolution other than going to court. Private judging, which might be only working as a settlement judge or an all-purpose judge to keep the case out of the court altogether other than filing papers. And then there's mediation. Mediation, I find, can be a really good method of resolving a dispute, particularly when people are ready. I would say the best case for mediation would be one where the parties have no children, they've been separated for a long time and maybe worked through a lot of the emotion that goes with divorce and separation. And they have equal bargaining power, meaning perhaps equal in education, equal in knowledge, equal sophistication in dealing with financial issues, and perhaps equal or roughly equal income, so it's not as likely they'll have a support dispute. I'm not saying that more complicated cases can't be resolved in mediation, but what I often see after the fact is some folks that aren't really ready, prepared, and as financially sophisticated enter into poor agreements that are not in their interest in mediation, and they didn't understand that until later when a problem comes up and they recognize they've made some bad mistake, perhaps given up a support right they otherwise would have been entitled to, or they fall into a tax trap they didn't anticipate. So you see a lot of set-aside motions in court where someone who feels aggrieved by a settlement agreement tries to set it aside later on some basis, and you see a lot of these coming out of mediation. And unfortunately, there are folks out there performing mediations that aren't really qualified, particularly non-lawyers. I've seen some horrible agreements where you read them and you don't even understand what they mean.
So, yeah, I would think that in a mediation you'd want to have an attorney involved because attorneys they're experts in putting together agreements.
Yes, absolutely. I would never recommend going to mediation over a financial settlement with someone other than a qualified attorney who has experience working in the area, because there are a lot of traps that if you don't know what you're doing. For example, you could think that you were entering into an agreement to provide for tax-deductible spousal support, but if it isn't written following the rules in the Internal Revenue Code, you may later find out that it's either not deductible or that it's subject to recomputation later, where you have to pay back what was otherwise deducted.
Yeah. So I know that there's some language even in our codes that doesn't seem to jive quite, with the requirements for the Internal Revenue Code, because of one, the Internal Revenue Code was written a long time ago when alimony was called alimony, and so on, and so and it seems like that they're trying to blend, and we're going to go into this probably in some more detail in our other discussion, but anyway, they try to sort of blend these things about child support and alimony, and then basically what that can do is just make the whole thing non-deductible.
That's right. And there can be confusion even in the area of child support. Does someone qualify for head of household status? Somebody might enter into a child support agreement thinking they're going to have head of household status, which would lower their tax rate, and then find out later that they don't qualify, and so they've have an amount of support that's being paid that's inconsistent with their expectations as far as their tax filing status.
Yeah, And by the way, this whole area of head of household now is up in the air because President-elect Trump has said, as part of his tax proposal, that he would eliminate head of household filing status. But there's some discussion that's going back and forth, and I don't think that one's going to hold up in the negotiations, so we'll see. Stay tuned. Anyway, okay, well, I think we've hit a lot of our main points. So maybe you have some more observations so that you can sort of throw in about this. Well, one thing that I was going to ask you about is, have you had an experience working like with a divorce coach in that sort of process? And I think they're trying to sort of deal with a lot of the emotional issues with the family and so forth and so on. Could you maybe comment about that a little bit?
Sure. There are a lot of collateral people that get involved in the process, and I've never recommended anybody use a divorce coach, but I've had a number of my clients have on their own found divorce coaches that they found helpful. And where I've found, at least from my standpoint, where I've seen them be helpful is helping them get things done, maybe assembling documents, organizing documents, getting their forms filled out so they get folks to do some of the work and save money. When you have to sit there with your attorney for 10 hours filling out a form, that gets very expensive, whereas if you bring it in and it's almost ready to go, the attorney might spend 15 or 20 minutes reviewing it to make sure it's in proper form and make sure they understand it. So there's certainly things like whether it's a CPA or a divorce coach, that could be very helpful. And of course, a lot of people engage the services of mental health professionals, particularly early on, because of the emotional aspects of divorce. And a lot of people find that very helpful, both for them individually, and if there are children, it often helps them work through the difficulties of making child custody and visitation arrangements with the other parent. And that's where we see mediation really working. And in fact, before you can go to court and have contested ongoing child custody and visitation disputes, the law requires you to go to mediation, and the court provides mediation services through an arm of the court called Family Court Services. So anybody with children where they don't make their own agreement quickly will probably end up in mediation at Family Court Services, or if they opt to, they can hire a private mental health professional.
Yeah, so there's a lot of collateral issues, and the problem is, I mean, even as a CPA, when I'm sort of counseling clients, I mean, you sort of have to recognize your limitations. I'm trained, as a financial person. I try to be a good listener, but I'm not a trained psychologist. And in your case, you're dealing with really such an emotional area that it's probably even more so the case that it is good to get some of these other people to the table.
Absolutely, and some of the financial issues, some lawyers are very good with the financial issues, and my client may want me to put together some tables or something to present in court, but I can't testify. I'm an advocate.
Yes.
And so sometimes, even though we know the answer between the client and the attorney, you need a third party to be able to go up on the witness stand and present the testimony and get a document into evidence that summarizes financial issues in a way that's helpful to the court in making decisions.
Right. So another thing, I guess, is in most cases, I would think that each spouse should have their own counsel, and this is not an area probably where it pays to be a cheapskate.
No, and I think sometimes the cheapskates get the short end of the stick. Certainly, if your spouse is represented, at a minimum, you should probably consult with an attorney to make sure before you sign any agreements that you understand what you're doing, or if you have a court appearance, you get some advice before you go unrepresented, because the consequences of making a mistake can be severe.
Right. So there's that old saying that only a fool would try to. Well, you have a fool for a client if you're acting as the attorney for yourself, or something like that.
Yes. And you see some attorneys in court trying to represent themselves.
Well, I mean, I guess if that's your forte, you're already a divorce attorney, but again, people, this is a complex area that we're talking about. The stakes in many cases can be very high. And so, I think it's important to get some good minds in there, and especially that, the attorney is in a position of sort of, I'm trying to be the attorney to both if they're trying to do this, for both. And it's hard to do that. I mean, they're just conflicts of interest that just naturally arise.
Yeah, you really can't do it because there's a conflict of interest. So if you're a mediator, of course, you're an intermediary, and you're not advocating for either of them, but you couldn't possibly represent the interests of both sides because of the conflict of interest. Helping one person is against the interests of the other often, and so it just doesn't work, and you don't see that. When I started practice 36 years ago, I think there were lawyers in those days trying to represent both parties, but you just don't see that happening anymore. I think sometimes people fall into the trap of thinking that their spouse's attorney is representing both of them, but that isn't the case.
Mm-hmm. Okay, well, we only have about a minute left, so do you have a final thought you want to throw out, or?
Well, I guess it's important for people to try and minimize expenses while looking out for their interests, and that there's often a balance in doing that. You want to pick your battles and try, certainly avoid some of them. You don't want to get caught up, fighting about pots and pans. People will spend sometimes tens of thousands of dollars over arguing what day their spouse can go back to the family residence to pick up personal belongings. And those sorts of disputes just are not efficient. They make money for a lot of people, but not for the folks that are fighting about it.
Okay. Thanks for joining me, Mark.
Thank you.
Okay, folks, that's it for today. We'll see you next time on Financial Insider Weekly.